Good afternoon. My name is Donohue. I am a law professor here at UC Davis. I'm delighted to welcome you all this afternoon to another lecture, the beginning of our spring semester series in our Surveillance Democracy Colloquium. So we're delighted this morning to have with us Professor Laura Donohue from Georgetown Law School. Professor Donohue is the director of the Georgetown Center on National Security and Law and director of the Center on Privacy and Technology. She has a PhD in history she has a PhD in history as well as a JD from Stanford Law School. Her PhD in history is from Cambridge. And she has a new book, which she will mention. And we are really privileged this afternoon to be the first audience that will get to hear about this book. The book is going to be out in a month from Oxford, and so I'm sure it will be very sought after at that time. She has a prior book in 2008 from Cambridge. It's called Cost of Counterterrorism, Power, Politics, and Liberty. And most recently, for those who have been following the 2015 surveillance reforms that were enacted this last year by the U.S. Congress and signed into effect by President Obama in the USA Freedom Act. The USA Freedom Act created 5 positions of advising the Foreign Intelligence Surveillance Court for various issues that arise before that court. And so the court has designated her one of the people, one of these 5 amici that they will turn to for advice in the coming years. So it's a delight to welcome Professor Donohue here with us. Let's welcome her.
Thanks very much. It's really lovely to be back here in Davis. I'm actually from the Bay Area. My sister lives in Folsom. My aunt was in Sacramento. My whole family lives in the Bay Area. So it really feels like coming home, and I really thank you for welcoming me here. And particularly thank you to Lian, Lee, to Anupam, and to Chris. Chris, thank you so much for inviting me to be part of this series. As I mentioned, when I looked at the speakers in this series, I wish I were here to hear all of these speakers. I look forward to watching them online. It's just a terrific series and a deep dive into a lot of issues that I think about a lot and that I care deeply about. My approach to this is through history, through national security, and through constitutional law. So what I'd like to do today is I'd like to suggest that the purpose of the Fourth Amendment was to prevent the government from using general warrants to try to pry into citizens' private lives. The founding generation, like their English predecessors, offered strong arguments against what is known as promiscuous search and seizure, which is what a general warrant allows the government to do, to search for evidence of potential wrongdoing without naming a crime, a particular place to be searched, or a particular person on whom to serve that warrant. I'm going to begin with a brief introduction, followed by a 17th and 18th century commentary on English legal scholars' rejection of general warrants. And then I'll turn to the colonial experience and early state constitutions that really gave birth to the Fourth Amendment. I'll conclude with some thoughts about the role of general warrants in the digital age. So since the earliest days of our republic, political and military leaders have recognized that U.S. national security depends upon the collection of intelligence. On June 13th, 1775, the New Hampshire Committee of Safety tipped off the Provincial Congress in Massachusetts that the British were planning to send troops to occupy the hills surrounding Boston by a gentleman of undoubted veracity, they reported, who had frequent opportunity of conversing with principal officers of General Gage's army. We're informed there's a great probability there, when the reinforcement arrives from Europe, that they will try to secure these posts. Well, the Army immediately used this information to its advantage. Colonel William Prescott, shown here on the slide, he led 1,200 soldiers to build defenses on that contested ground, and he caught the British flat-footed. Now, the British troops ultimately prevailed, but they suffered heavy losses, with more than 1,000 men wounded or killed. The clash became known as the Battle of Bunker Hill. It played a crucial role in the U.S. Revolution, igniting colonial morale and really sending a message across the Atlantic that this war would not be won either quickly or easily. Throughout the Revolution, intelligence played a key role. General George Washington spent more than 10% of his military funds on surveillance. He established networks of spies up and down the East Coast, directing them to collect information and to report back to him. As Washington explained to Elias Dayton, he ran the operation actually on Staten Island. He said, the necessity of procuring good intelligence is apparent. And a peace, of course, brought with it new demands, not least to help the president negotiate the perilous waters of diplomacy, really, overseas. And in his first State of the Union address, Washington requested a competent fund to finance foreign affairs. Within 6 months, Congress had established the Contingent Fund of Foreign Intercourse, known as the Secret Service Fund, to be used for spies for the president. John Adams, Thomas Jefferson, James Madison, all subsequent presidents have acknowledged and really spoken of the need for intelligence. Why? Well, without information about threats, the country is in peril. So Congress and the courts have really given the executive branch wide latitude to determine how they collect this information. At times, though, the executive has been so aggressive about its courts that it's run afoul of the Constitution. At such moments, the courts and the legislature have stepped in to rein it in. The 1970s marked one such moment in U.S. history. The Church Committee hearings revealed widespread government surveillance. So the NSA, the CIA, the FBI, the Department of Defense, the U.S. Army, the U.S. Post Office, the IRS, and others, all had placed ordinary law-abiding citizens under surveillance. Congress responded by passing the Foreign Intelligence Surveillance Act, which we now know as FISA. It was to be the exclusive means through which the president could conduct wiretapping on U.S. soil. Both the courts and Congress agreed this was the exclusive way that the president could act. Through this statute, the legislature really tried to provide the president the ability to deter external attacks, to ensure domestic security, and to restrict the executive, and to protect against overreach, while at the same time preserving rights, individual rights. And the court subsequently and repeatedly considered this legislation to be a constitutional exercise of Congress's power and a constitutional limit on the executive when conducting electronic surveillance. Now, for 3 decades, nearly, the equilibrium held, but the attacks of 9/11 radically shifted that landscape. The executive branch immediately took advantage of new and emerging technologies, bypassing FISA altogether, to introduce the Terrorism Surveillance Program, which collected all telephone content and metadata, as well as internet metadata and content in the United States, in the importance running roughshod over important limits that the founding generation, for good reason, cemented into our Fourth Amendment. Now, later efforts to shoehorn those programs into FISA, the 1978 Act, led to a contorted reading of the law, one that has been hidden from public view until very recently by the classified nature of surveillance and national security until the leaks forced this information into the public domain. What these documents show is that general warrants, which the framing generation rejected, they've really returned with a vengeance. At risk is the right to privacy of all of us in this room, of all U.S. citizens, as well as the balance of power in the United States. And my concern is that the stakes could not be higher as we enter the digital age. So what is a general warrant? Well, a general warrant is a document that's issued by a court or by the executive branch that gives officials the broad authority to search for and to seize private documents without any prior specific evidence of wrongdoing. It does not specify with particularity the person or place to be searched, or the papers or records to be seized. It's not supported by oath or affirmation of any wrongdoing. It amounts to a fishing expedition to try to find evidence of wrongdoing. For centuries prior to the American founding, English jurists and legal scholars rejected general warrants as the worst exercise of tyrannical power. During the reign of Charles I, Sir Edward Coke argued in Parliament against the use of general warrants, even for threats to the realm. If such instruments be used per mandatum domini regis, or for matters of state, he thundered, then we are gone, and we are in a worse case than ever. If we agree for matters of state, we shall leave Magna Carta and other statutes and make them fruitless and do what our ancestors would never do. The 1628 Petition of Right went on to condemn general warrants. Now, Coke returned to his arguments in the Institutes, in the third part of his Institutes of the Law of England. To issue general warrants, he wrote, is against Magna Carta. Preventing their use lay at the heart of the rule of law. Nec super iam ibimus, nec super iam minimis, nisi per legale judicium parium forum vel per legem terrae. Neither will we pass upon him or condemn him, but by the lawful judgment of his peers or by the law of the land. Coke's rejection of general warrants reflected a growing frustration at this ever-expanding use of general warrants. Now, ironically, his institutes actually fell subject to a general warrant, to the very warrants that they condemned. As Coke was dying in his deathbed, Charles I ordered, under a general warrant, that everything in his possession be seized. In fact, the king himself broke open the trunks when they arrived. Even as his execution, Charles I's execution, ended the divine right of kings, however, legal scholars began cementing Coke's thoughts into English legal thought. In 1678, Sir Matthew Hale, an intellectual giant most famous for his 1739 History of the Common Law of England, he noted in his first volume of Pleas of the Crown a general warrant to search for felons or goods, not good. Very succinct. 2 years later, Parliament directed publication of his manuscript. When Historia Passatorum Coronae finally came out, this is History of the Pleas of the Crown, in 1736, it was enormously influential. In it, Hale stated, a general warrant to search in all suspected places is not good, but only to search in such particular places where the party assigns before the justice his suspicion and the probable cause whereof. For these warrants are judicial acts and must be granted upon an examination of the fact. He continued, therefore I take those general warrants dormant, which are made many times before any felony committed, are not justifiable, for it makes the party in effect to be the judge. Therefore, searches made by pretense of general warrants give no more power than what they may do by law without them. Now, for centuries, English courts looked to these treatises and rejected the concept of a general warrant. It was, for instance, to Hale that Lord Mansfield later appealed in a case brought over the Crown's effort to prevent publication of North Briton number 45. In 1762, John Wilkes had founded the North Briton in opposition to the Briton, which was a pro-government newspaper. He founded the North Briton and began lampooning the Crown generally, and particularly George III's favorite, John Stuart, the third Earl of Bute. When he introduced negotiations with the French, which brought the 7 Years' War to conclusion, the North Briton and others really attacked the terms of peace. Wilkes, shown here in a not particularly flattering engraving of Wilkes, he lamented the French king by a stroke of his pen has regained what all the power of that nation and her allies could never have recovered. Now, political hostility forced Bute's resignation, but the North Britain's attacks continued. So when Grenville assumed the office of Prime Minister and sanctioned that same Treaty of Paris, which Wilkes had condemned, he condemned it as having saved England from the certain ruin of success. He lamented seeing the Crown sunk even to prostitution. This time, Wilkes had gone too far. 3 days after this was published, North Briton number 45 was published. Lord Halifax signed a warrant which authorized the King's messengers to make strict and diligent search for the authors of North Briton 45 and to apprehend and seize them together with all of their papers and possessions and bring in safe custody before Lord Halifax to be examined. So in the melee that followed, there were dozens of actions that challenged the government's general warrant. In Wilkes v. Wood, this is one of the cases that came forward, Wilkes's lawyer was John Glenn. He argued that much more was at stake than the simple execution of one warrant against one person. At stake were the rights of all Englishmen. In vain has our house been declared by the law our asylum and our defense, if it is capable of being entered upon any frivolous or no pretense at all by a Secretary of State. So the seizing of these papers for Wilkes represented one of the worst offenses against the Crown's subjects. For other offenses, an acknowledgement might make amends. But for the promulgation of our most private concerns, affairs of the most secret personal nature, no reparation whatever could be made. English law, Glenn argued, never admits of a general search warrant. Beyond the privacy invasion involved here was the risk that accompanied the proposition that some papers, quite innocent in themselves, might, by the slightest alteration, be converted to criminal action. So the idea is innocent information could be combined in such a way as to make it look as though individuals had engaged in illegal behavior when in fact they hadn't, which would allow the Crown to go after political enemies. It would allow them to target whoever they wanted and to try to amass information, private information about them, to embarrass them or to make false criminal charges against them in the process of exercising a general warrant. After only a half-hour deliberation, the jury returned a verdict for Wilkes, awarding an astonishing £1,000 in damages. 2 days later, the St. James Chronicle reflected, by this important decision, every Englishman has the satisfaction of seeing that his home is his castle. Recall that in 1604, Cook, in Semane's case, famously stated, "The house of everyone is to him his castle and his fortress, as well for his defense against injury and violence as for his repose." Now in that case, Cook recognized limits on the Crown's ability to intrude into the private homes of the king's subjects. 24 years later, he incorporated that principle into his institutes. For a man's house is his castle, et domus sua sique est tutissimum refugium, and each man's home is his safest refuge. That's the language that the St. James Chronicle referred to in its assessment of Wilkes v. Wood. Now, 2 years after that case, Lord Chief Justice Mansfield of the Court of the King's Bench similarly found himself confronted by a warrant executed in response to North Britain number 45. Dryden Leach, in this case, was the alleged printer of the publication. Like Glynn, John Wilkes's counsel, Dunning, who represented Leach in this case, argued that the generality of the warrant is what made it illegal and unconstitutional under the British Constitution. Here is no probable cause, he stated, nor any reason for justifying the officer under a probable cause. If such a warrant could be issued, directing those executing it to find those responsible without naming the target, such a power, he stated, would be extremely mischievous and might be productive of great oppression. Now, Dunning appealed to inalienable rights in this case, to ransack private studies in order to search for evidence, and even without previous charge on oath, is contrary to natural justice, as well as to the liberty of the subject. And he continued to search a man's private papers ad libitum, and even without accusation, is an infringement of the natural rights of mankind. Now, Lord Mansfield, who presided over the case, agreed. He noted Hale and others hold such an uncertain warrant void, and there is no case or book to the contrary. The judgment stood. Now, these were hardly the only cases to condemn general warrants. In Intick v. Carrington, Chief Justice Charles Pratt contemplated an action in trespass against the Crown for execution of a general warrant against John Intick. Pratt, ruling against the government, observed, "The great end for which men enter into society is to preserve their property." So under English law, every invasion of private property, be it ever so minute, is a trespass. And by this, Pratt did not mean physical intrusion of the home. Papers, he said, are the owner's goods and chattels. They are his dearest property, and so far from enduring a seizure that they will hardly bear an inspection. So by 1776, members of the House of Commons referred to the writs in even more derisive terms. A general warrant, one member commented, is such a piece of nonsense as deserves not to be spoken of, being no warrant at all. 2 years later, William Blackstone, in his commentaries on the law of England, underscored the distinction between specific and general warrants. The latter, illegal and void for its uncertainty, for it's the duty of the magistrate, and ought not to be left to the officer to judge the ground of suspicion. So by the time of our founding, English legal treatises, English case law, under all of the authorities in England, general warrants were not to be tolerated, even, as Cook noted, for reason of state, which is similar to what we now understand of as national security. Why? General warrants violated Magna Carta. They undermine the rule of law. Criminal procedural protections would mean nothing if they simply could be bypassed every time the government claimed it was for reason of state or for matters of gravest concern. Even specific warrants could only be tolerated if they carried sufficient particularity, naming the person, the suspected crime, evidence for the suspicion, under oath, the particular place to be searched. The decision of determining what to search should not be left to the person carrying out the search. That transferred too much power to the crown. So when American colonists left England, they expected that their rights as Englishmen would continue with them, would traverse the Atlantic Ocean with them. But in the New World, general warrants started proliferating again, this time in the form of writs of assistance, which is basically a general warrant issued by naval officers or customs inspectors to search for contraband in the colonies. Any person presented was required to assist the officers. That's why it was called a writ of assistance. In the context of the French and Indian War, British governors of the colonies turned to writs of assistance as a way to prevent France from benefiting with illegal trade with the colonies. The Massachusetts Bay Governor, William Shirley, initially relied upon his executive power to issue a writ that directed the customs agents to search for contraband in local homes and warehouses. Loyalists objected to this, forcing Shirley to actually get a judicial writ instead. Now in 1760, the Crown redoubled its efforts. So William Pitt the Elder, who was the Southern Secretary of State, directed the then governor of Massachusetts, Sir Francis Bernard, to stop not just northern trade, but all trade with the French Indies, between French Canada and the colonies, and then down with the French Indies as well. A few months later, George II died. Now, whenever a monarch died, any general warrants had to be renewed under the new monarch. They were only good for 6 months. This gave the merchants an opportunity to challenge the constitutionality and legality of general warrants, and particularly writs of assistance. They chose one of the leading lawyers of the time, James Otis Jr., who resigned his position in the government in order to take the case. His oration in what's come to be known as Paxton's case, named after one of the customs agents who served the general warrant, is one of the most famous in U.S. history. More than 50 years after the event, President John Adams, our second president, who was there at the time, he wrote, "Otis was a flame of fire. His argument breathed into this nation the breath of life. He continued, every man of an immense crowded audience appeared to me ready to go away as I did, ready to take up arms against writs of assistance." Professor A.J. Langmuth has later reflected, Otis stood up to speak, and something profound changed in America. Otis attacked the idea that the Crown should have the authority to enter and search premises to look at the private papers of British subjects. "I will to my dying day oppose with all the powers and faculties God has given me, all such instruments of slavery on the one hand and villainy on the other, as this writ of assistance is." It represented the worst instrument of arbitrary power, the most destructive of English liberty and fundamental principles of the Constitution that ever was found in an English law book. He harkened back to Charles I and James II and noted it was this type of despotic power that had cost one king of England his head and another his throne. And the reason is that every person who carried a general warrant or a writ of assistance had the potential to be a tyrant. And not just a tyrant, but a tyrant sanctioned by law. Individuals could use the writ to take revenge on others or to target political opponents. Those who were served with one, in turn, were forced to comply with it. At base were concerns about the sanctity of the home and the importance of privacy and ensuring security. One of the most essential branches of English liberty, Otis noted, is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. A writ of assistance, if it should be declared illegal, would totally annihilate this privilege. Our second president later reflected, then and there was the first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child independence was born. Americans were eager to ensure that the new state governments did not have the power to override fundamental rights. Accordingly, in 1776, the Fifth Virginia Convention assembled really a pantheon of the American Republic. If you think about it, Patrick Henry, George Washington, Edmund Pendleton, George Mason, George Wythe, Richard Henry Lee, Thomas Jefferson, and others. To Mason, of course, fell the responsibility of drafting the Virginia Declaration of Rights. And in that document, Mason laid out the natural rights of man. He drew from Locke and Montesquieu, English history and colonial experience. And he said, individuals have certain inalienable rights which limit the power of the government. Amongst these, in this document, was the right to be free of general warrants. The Virginia Declaration of Rights states that general warrants, whereby any officer or messenger may be commanded to search suspected places without evidence of a fact committed, or to seize a person or persons not named or whose offenses not particularly described and supported by evidence, are grievous and oppressive and ought not to be granted. The right against promiscuous search and seizure lay at the heart of the founding. Along with the principle of consent and the right to a jury trial, it freed the colonists from tyrannical rule. And Virginia was not alone in its condemnation of general warrants. In July of 1776, Benjamin Franklin, George Bryan, James Cannon, Thomas Paine, and others drafted a new constitution for Pennsylvania. It established security from searches and seizures as a right held by the people. Specifically, it read, "The people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures, and no warrant to search any place or to seize any person or thing shall issue without describing them as nearly as may be, nor without probable cause supported by oath or affirmation subscribed to by the affiant." Now, by using the word unreasonable, Pennsylvania meant something different than what is commonly attributed today to the Fourth Amendment. Unreasonable in the 18th century meant against reason, which meant against the reason of the common law. This was a very common trope. So the common law was understood to be reflective of reason. And so something that was against the reason of the common law was unreasonable. If it violated the common law, it was illegal. So general warrants were unreasonable. They were against the reason of the common law and therefore illegal, prohibited. Delaware, Maryland, North Carolina all followed suit. Now, these early state constitutions really transformed a colonial grievance about the Crown's violation of the rights due to Englishmen into a written guarantee of an individual right. So when the founders rewrote the Articles of Confederation into the U.S. Constitution, state after state after state demanded that there be a clause outlawing general warrants. The liveliest and most intense exchange really took place, not surprisingly, in Virginia. Patrick Henry was the charismatic former governor. He led the attack. He really worried that the new Constitution imperiled Americans' rights and privileges, as well as the sovereignty of the state governments. He demanded that a Bill of Rights be added to ensure the protection of ancient liberties. "I feel myself distressed," he said, "because the necessity of securing our personal rights seems not to have pervaded the minds of men. For many other valuable things are admitted, for instance, general warrants, by which an officer may search suspected places without evidence of the commission of a fact, or seize any person without evidence of his crime. They ought to be prohibited." The problem was that property could be taken in the most arbitrary manner, without any evidence or reason, so everything sacred could be searched and ransacked by the strong hand of power. The Virginia Declaration delegates went on to establish, as part of a proposed Bill of Rights, the protection against unreasonable search and seizure by eliminating general warrants and requiring further specifics before even a specific warrant would be valid. Article 14 of its proposed measures stated that every freeman has the right to be secure from all unreasonable searches and seizures of his person, his papers, and property. All warrants, therefore, to search suspected places or seize any freeman, his papers, or property without information on oath, etc., are grievous and oppressive, and all general warrants to search suspected places or to apprehend any suspected person without specifically naming or describing the place or person are dangerous and ought not to be granted. So the debates in New York similarly highlighted the absence of a measure discussing general warrants. For Rhode Island, it was only with the understanding that the Constitution would be amended to take account of the prohibition on general warrants that it would ratify the Constitution. In Maryland, Anti-Federalists warned that under the new Constitution, excise officers would have the power to enter your home at all times of day or night, break open your rooms, break open your doors, chests, trunks, desks, boxes, and rummage your house from bottom to top. Maryland also proposed that a Bill of Rights prohibit general warrants and laid out the particulars that would be required for even a specific warrant to be valid. In Massachusetts, Pennsylvania, North Carolina, similar conversations took place, prompting Madison, when entrusted with the Bill of Rights, to vow to protect the rights of conscience, the freedom of the press, trials by jury, and security against general warrants. And so we come to the Fourth Amendment of the Constitution, whose language establishes the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the first part of this clause prohibits general warrants. The second part says that even for a specific warrant to be valid, it has to meet certain criteria. With that history in mind, one could perhaps be forgiven for being somewhat surprised on June 6th of 2013, when The Guardian announced that the United States was collecting the phone records of millions of Americans. The order required Verizon to turn over all call detail records of telephony metadata created by Verizon Communications between the United States and abroad, or wholly within the United States, including local telephone calls. Issued by the Foreign Intelligence Surveillance Court, the order did not name any individual suspected of wrongdoing, did not specify a crime. There was no oath or affirmation. The order did not indicate the particular place to be searched. Indeed, it did not appear to be tailored in any way whatsoever. It empowered the intelligence agencies and, as it turns out, federal law enforcement agencies, because this information could also be used for ordinary law enforcement, it's an important point, to obtain private papers under a judicial writ. Anyone served with the order was required to comply, and rather than starting at the outset with information indicating illegal behavior and presenting it under oath to a judge, it was being used to find potential evidence of wrongdoing. In short, it was a general warrant. Now, some people have argued that the information being collected under this order was not private, and so it didn't deserve the protections of the Fourth Amendment. This statement does not survive scrutiny. The order demanded documents detailing citizens' friendships, private conversations, social networks, and relationships, as well as their location. The information collected revealed where they were located 24 hours a day, 7 days a week, for years. It demanded that that information be turned over to the government. It's important to note here that a significant amount of personal information is entailed in even telephony metadata. There was a recent study by computer scientists at Stanford University where they looked for a few months at the telephone records of 546 volunteers. They looked at the numbers dialed, patterns in calls, and they were able to ascertain highly sensitive private information. So one participant in his study spoke at length with a cardiologist at a medical center for a short time with a medical laboratory, and then received calls from a pharmacy and telephoned a home reporting line for a medical device used to monitor cardiac arrhythmia. Another participant called a firearms store specializing in AR-15 semi-automatic rifles before telephoning a customer service manufacturer for a manufacturer that produces the AR-15 line. A third participant called a home improvement store, a locksmith, hydroponics dealer, and a head shop. You kind of want to say, you're in a study. They knew they were doing this, right? But anyway, all right. I'm from here. It's okay, you're in California. The fourth person phoned her sister, spoke with her at length. 2 days later, she called Planned Parenthood. A fortnight later, she telephoned the clinic a few times, and a month later called a final time. That metadata provided insight into the participants' heart conditions, gun purchases, cannabis cultivation, and decision to have an abortion. And it was a small sample over a short period of a limited number of calls. The Verizon order, it turned out, had been in place for almost a decade. It carried the imprimatur of the courts. It was a judicial writ, and it demanded that anyone served with it was forced to comply, and it was being used to find potential evidence of illegal activity. To be sure, there are differences between the writs that the framers worried about and the general orders, the general warrants that we are seeing today. The 18th century was not a digital era. It was the physical entry into one's home that protected the privacy interests of the state, whereas now information can be collected without ever entering into the curtilage of the home, without any physical trespass. Additionally, at the founding, if an individual's home was being searched, everybody present could see and hear it, and so embarrassment was one of the key factors, whereas now, for almost a decade, none of us knew that this was happening until those documents were released. Setting those differences to one side, however, these orders are strikingly consistent with the general warrants that caused the founders so much concern. That an Englishman's home was his castle figured largely in anti-federalist writings. Embedded in this concept were deeper understandings about an individual and what one ought and ought not be forced to make available to the government. Access to one's castle meant access to one's family and friends, one's bedroom, one's bathroom, one's books, one's correspondence. It meant access to our most intimate secrets. Further implicated was the right to solitude, as well as the right to relax, to be unguarded in our actions and ideas, and the ability to question the world and our role in it. Who we are, who we want to be, and how we evolve takes place in part within a protected space. We can interact with our own thoughts, our ideas, and our beliefs, our ability to form intimate relationships, and to decide for ourselves different degrees of intimacy in our relationships. All of this contributes to our own development, as well as the strength of the social fabric. Underlying these ideas is the basic understanding that when we are subject to surveillance, we change our behavior. To have others watching us acts on us in ways that restrict or limit or alter how we can grow, and it infringes on our relationships with others. Democratic deliberation, in addition, turns on our ability to discuss ideas, however unpopular, however contrary to the views of the prevailing administration, so that we may subject thought to this marketplace of ideas, and through this develop deeper knowledge, deeper understanding, deeper values. These ideas were alive in colonial times. This is what they discussed and what they worried about with regard to general warrants, when the tight and complex relationship between individual rights such as privacy and free speech and due process and free association, it was understood and discussed and debated and valued at that time. Yet other sets of arguments also marked the founders' concern for promiscuous search and seizure, such as the potential harms that could follow from the government amassing too much information about the citizens and having too much information in one place. For one, the approach got the presumption wrong. Instead of innocent until proven guilty, everybody was assumed potentially guilty until your information showed that in fact you were innocent. For another, approaching potential wrongdoing in this manner risked the possibility that the government, the Crown, and then the nascent US government would target political opponents, people who had different ideas or beliefs or thoughts about how the country should progress. This power was ripe for abuse. It could be used to prevent social, political, or economic opposition, either through uncovering like illegal activity or by using intimate information to gain insight into people's lives and to interrupt social relationships, then using it to prevent opposition, to shift opposing views, or to disrupt organizations. The amassing of this kind of information could override the structural division of power between the branches, as well as federalism, giving the government more insight into state and local level. Because of this enormous potential for harm, the founding generation considered general warrants for search even more concerning than general warrants for arrest. General warrants for search were the very definition of tyranny. Now, on June 2nd, 2015, Congress passed the USA Freedom Act, which gave the Section 215 program until November to continue. This is the telephony metadata program. Because of this, some people argue we really don't have to worry, the problem has gone away. Yeah, this argument is a red herring. That's best as I can tell. The advent of big data, the potential of new analytical tools, paired with new ways in which technology has really catapulted our world forward, make this really one of the most pressing questions of our times. Telephony metadata collection under Section 215 is not the only game in town. Myriad other mass collection programs are underway, giving the government insight into our most private affairs. Again and again, we hear from government officials the promise that the accumulation of massive amounts of information hold for the future. You need the haystack to find the needle, the director of the NSA, former director John Keith Alexander says. Michael Hayden, former CIA and NSA director, he agrees with this. Their comments have been repeated throughout the government. Mr. Inglis, John Inglis, he's been at the NSA for 3 decades. He's explained you have to have the whole haystack to find evidence of wrongdoing. So the idea is that by collecting everything, by tagging it, by storing it, by subjecting it to analysis, the information can then be searched to find evidence of illegal behavior. We're told that these programs provide the government greater insight into the threats that we face as a country. That statement is undoubtedly true. It's also true that the collection of that information allows the government incredible insight into our daily lives. Leaked documents suggest that the NSA is scanning communications that travel across the backbone of the internet, as well as intercepting data between servers overseas. Information is fed into massive databases where it then can be queried. According to the NSA, in 2013, the agency conducted 20 million queries per month. 20 million queries per month. Even when data is collected by targeting foreign countries, entities or individuals, the NSA can use US person identifiers to search those databases. And every time we communicate, and it happens to go internationally because Yahoo Mail happens to be held in Singapore on a server, that then can be subjected to surveillance. In short, large-scale mass collection looks a lot like what the founders were trying to avoid by preventing the government from using promiscuous search authorities. It's precisely what Otis protested, and it gave birth to the Fourth Amendment. Persistent collection of citizens' private information with the purpose of finding evidence of wrongdoing without any oath or affirmation or probable cause, and without particularly describing the person or places to be searched, or persons or things to be seized, flies in the face of our constitutional doctrine and is, in my view, on its face, unconstitutional. Thank you.